Okay, why don't we get started? First, I'd like to thank everybody for joining us tonight. It is an excellent panel we have put together, and we're very excited about it. To start off the new year on a very high note, that we have passed this amendment, and now we will discuss it tonight. It is a very rare opportunity to be able to be in the presence and hear a discussion from three wonderful, reputable attorneys, and to not even have a bill at the end of the night. We are thrilled to have them. And to start us off with welcoming remarks, we have State Senator Pete Harckham. Senator Pete Harckham was elected to the New York State Senate in 2018. Prior to his election, Senator Harckham has had a distinguished career in public service, where he has served as Assistant Director of the Office of Community Renewal and the Director of the Intergovernmental Affairs Office for the Governor Mario M. Cuomo Bridge Project. He also served in the Westchester County Legislature for 7 years. Senator Harckham is the chair of the Alcoholism and Substance Abuse Committee and also serves on other committees, including Environmental Conservation, where he has produced many substantial pieces of environmental legislation regarding electric vehicles, radiation data, zero emission lawn and landscaping equipment, ensuring a safe decommissioning of Indian Point, and much more. Senator Harckham.
Thank you very much, Matt, and good evening, everybody. It's really a thrill to be here with all of you and this really powerhouse panel. First, I want to thank Clearwater for your many decades of advocacy and education of many generations of stewards of the environment. And when Matt mentioned the decommissioning board for the safe and just oversight and decommissioning of Indian Point, Clearwater was one of the leading advocates that helped us build momentum to create that legislation and work with the prior governor to get that done. And I also want to thank Clearwater for putting this panel together. You know, this is an important conversation. The good news is we've passed this. This is now the 19th Amendment to the New York State Constitution. So to all of you who work so hard to influence policy, congratulations. You know, so often we're on Zooms talking about policy, about the fight, about the fight, about the fight. It's so nice to be on a Zoom. Take a victory lap. Thank you. It's all of you, the advocates and the people on this panel who made this successful. You know, as sometimes as legislators, we tend to be generalists because we have so many topic areas, and we rely on advocates like you to educate us and educate the public, and you were so successful. This is such an important amendment in that for the first time, New York State and local governments will need to prioritize the environment and public health like they have not in any way, shape, or form in prior generations. This will be big. And it's interesting because everyone has a different interpretation of how this will be implemented. And that's a great thing about this panel tonight, is we're going to hear different opinions on how this can impact in a positive way the health and safety and quality of life of New Yorkers. So I'm thrilled to be here, and I'm thrilled to listen to what our panelists have to say. And thank you for all you do for the Green Amendments movement.
Thank you, Senator Harckham. I will now begin to introduce some of our panelists, starting off with Maya K. Van Rossum. She is the founder of Green Amendments for the Generations, a national nonprofit organization dedicated to inspiring a movement to amend state constitutions, to recognize and protect environmental rights on par with other inalienable civic and political freedoms. She has been called the mother of the Green Amendment. Maya has also served as Delaware Riverkeeper for 28 years and is author of the book, The Green Amendment, Securing Our Right to a Healthy Environment. Maya, glad to have you. Our next panelist is Nicholas Robinson. Professor Nicholas Robinson has developed environmental law since 1969, the same year I started, when he was named to the Legal Advisory Committee on the President's Council on Environmental Quality. He has practiced environmental law in firms for municipalities and as general counsel of the New York State Department of Environmental Conservation. He has served as a legal advisor and chair of the Commission on Environmental Law of the International Union for the Conservation of Nature and Natural Resources. He founded PACE's environmental programs, edited the proceedings of the 1992 UN Earth Summit in Rio de Janeiro, and is author of several books and numerous articles. And our last panelist is Seth Davis, who has practiced environmental law for over 40 years in corporations, law firms, and now as a solo practitioner. He is a former chair of the American Bar Association section on environment, energy, and resources law, and is a member of the ABA House of Delegates representing that section. He has taught for many years as an adjunct professor at the Elizabeth Holb School of Law at Pace University, and is a former board member of Hudson River Slope Clearwater. So we'd like to begin tonight with a little bit of a primer about what a Green Amendment is, and we can think of no one better to do that than Maya.
Thank you so much, Seth, for that. Oh, I have to unmute myself. Am I unmuted now?
You're all good.
That's like the word of the day these days. So I really appreciate the opportunity to join in this most auspicious panel. I can honestly say that Professor Robinson has been my mentor since I was in law school. And it is a true honor to serve with him on this panel, to serve on this panel as well as Seth Davis, such a powerhouse for environmental law. I want to thank Clearwater for organizing this panel. And I really want to acknowledge also some of the key leaders that I, in my role as the Delaware Riverkeeper and my Green Amendments for the Generations organization partnered up with to really advance the New York Green Amendment. And that would be Environmental Advocates of New York and the New York Adirondack Mountain Club. They were key partners with us, right on the cutting edge to advancing this from day one, as was Professor Robinson and others at the Pace Law School. And I do want to note that I saw Professor Ottinger, who was also a professor of mine at Pace, that is on this session. And so I'm honored that he would take the time to attend. So you've already given my credentials, Matt, and I really super appreciate that. I think the most important thing for me that I want people to know about is that my founding of this concept of a Green Amendment and the National Green Amendments for the Generations movement is really an outgrowth of my 20 years of advocacy and environmental litigation as the Delaware Riverkeeper and leader of the Delaware Riverkeeper Network, and a truly amazing success we had in the Commonwealth of Pennsylvania when it came to constitutional environmental rights. But I'm not going to go into that story. That's in the book, and that's another talk. I'm just charged with giving a real short primer to make sure everybody's on the same page about what we're talking about here today. We are talking about, as Matt said, we are talking about raising up environmental rights, the right to clean water and clean air and healthful environments. So they are given the same most powerful legal and constitutional protection that we give to those other fundamental human, civil, and political rights we hold dear. Things like the right to free speech and freedom of religion, the right to peaceably assemble, private property rights, due process rights, the right to bear arms. That is fundamentally what we're talking about. But if you want to accomplish raising up environmental rights to this highest level, not just any language in the Constitution will do. In fact, almost every state, save for 4 or 5 by my count, talks about the environment, even in environmental rights, in their state constitutions, but only a few have been successful at raising up environmental rights to this highest level. So if you want to have a Green Amendment, what I've defined to be a Green Amendment, and raise up environmental rights, there are a couple essential fundamentals. The language has to be placed in the Bill of Rights section of the Constitution. That's where we place all of those other fundamental rights we hold dear. That's where we have to place our environmental rights. That isn't just a visual, that's not just aspirational. It actually brings very clear interpretations of the Constitution and law to bear on environmental protection in the same way they bear on these other fundamental rights. So Bill of Rights placement is a must-have, non-negotiable element of a Green Amendment. We have to be sure that we're being clear, that we're talking about the rights of all people, and that we're talking about rights that are essential to healthy lives. Things like water, air, and environments, as opposed to the right to things like fish, hunt, trap, and navigate. Those are certainly important to people, but the right to navigate a water body is vastly different for the majority of people than the right to clean water and clean air. So we want to be clear about the kinds of rights we're talking about. We need language that is self-executing, meaning that it has legal and enforceable strength and power in its own right, that it is truly self-executing. And if there's a gap in the law or a misapplication of the law, the people can turn directly to the constitutional language to defend their environmental rights. There are other elements that are very valuable to having a Green Amendment and having that most powerful strength, but those few items I just mentioned are amongst the non-negotiable essential fundamentals. There are 3 states already that have constitutional Green Amendments of this kind: Pennsylvania and Montana, and now, of course, the state of New York. So, you know, what we say is we welcome New York to the Green Amendment family. This is an extra slide just because it was fun. But at this point, with our Green Amendments movement, we have actually inspired Green Amendment proposals across the nation. There are 12 states now that have Green Amendment language that is being proposed and is in various states of the process towards actually being secured. Amongst those that are at the forefront of the movement are states like New Mexico, Hawaii, Washington, New Jersey, and Maine. The others are in there and they're in the mix, but those are the states where we could actually have true success in the coming year and get Green Amendments in those states over the finish line. How will having a Green Amendment change things? Just in broad strokes. It will mean that Green Amendments are given this highest, most powerful protection. We all know how powerfully private property rights, free speech rights, the right to bear arms are protected in people's hearts and minds, but also under the law. That same most powerful protection comes to bear for the environment. It will mean that all government officials at every level of government, from the town council through the state legislature to the governor's office and all the regulatory agencies in between, will be duty bound to protect the environmental rights of all the people. It will mean that there must be a focus on prevention of pollution and degradation first, not just accepting it as a foregone conclusion and hopping to the end of the process where we're thinking about what permits are we going to issue to legalize pollution, as opposed to how are we going to stop it in the first instance. But a Green Amendment flips this, and truly there must now be a focus on prevention of harm from day one of decision making. It will strengthen how existing laws are interpreted and applied. It will provide a defense when government does bad stuff, and it will provide a powerful foundation for government officials who want to do better when it comes to environmental protection, whether that's passing better laws and regulations or issuing better decisions. And when there's a gap in the law that is allowing harm to communities from pollution that is unregulated, like happened with PFAS, the Green Amendment language, because it is self-executing, can be turned to fill the gap. And it will be a powerful tool for strengthening environmental justice and ending environmental racism, because now all communities, regardless of race, ethnicity, or socioeconomics, we all have the same constitutional right to a clean and healthy environment, and all government officials are constitutionally bound to protect our environmental rights equitably. You can't have any more sacrifice zones when you have a constitutional Green Amendment. The goal of a Green Amendment is better decisions in the first place, advance the good, prevent the bad. The reality of a Green Amendment is when our government officials get it wrong, people have immediate access to the courts to try to vindicate their constitutional rights. And it doesn't just transform the law, although it does that in very powerful ways, but it also transforms the way people think about the environment and their environmental rights, the way they think about it in their hearts and their minds, and therefore the way they can advocate for it. Because they are not just advocating for environmental protection, they are now also advocating for a constitutional right that they are entitled to. Here's the language we're talking about that's going to be added or is being added to the New York Constitution, that each person shall have a right to clean air, water, and a healthful environment. This is the new environmental rights provision, what I call a green amendment, that's now part of the New York State Constitution and that we're here to talk about. So I hope that puts everybody on the same page and gives you a sense of how powerful and transformative this success truly is. Thanks, everybody.
Thank you, Maya. I'd like to go now to Professor Nick Robinson. Nick, what is specifically the New York Green Amendment? Maya just gave us a definition, but I'd like to have a little bit more background. How did it come to be, and why is it important?
Well, thanks a lot, Matt. And I echo the thanks to Clearwater for organizing this wonderful panel and program this evening. I want to acknowledge the really superb work that environmental advocates, Atlantic Chapter of the Sierra Club, Clearwater, and others did in campaigning for this amendment. It was adopted on November 2nd by a 2-to-1 vote. You may remember that we had 5 amendments sent by the legislature for the Constitution. Only one other passed, and it barely passed, dealing with the jurisdiction of some of the courts in New York. The other 3 didn't get adopted. So the voters clearly made a distinction between these 5 amendments, and they knew what they wanted with the environmental amendment, and they adopted it. So the Green Amendment became Article 1, which is our Bill of Rights, Section 19, Clause 19, the environmental rights of the people of the state of New York. This became effective at once. It's called self-executing. That means, as Maya said, you don't need any law by the legislature or a ruling by the court or others to put it into effect. It's in effect now. And it is a right that each person in this state has. Interestingly enough, the United Nations General Assembly is going to have a vote next session in November, probably, or December, on adopting a recognition that environmental rights are a fundamental human right. And I think it will be adopted. It may be debated and there may be a split vote, but I think we're going to see a recognition that back when we had the human rights developed with the Universal Declaration of Human Rights, they should have had the Environmental Right Amendment in there. And it is now moving into that very important spot. It couldn't come a minute too soon because we face tremendous challenges to our life and liberty, from climate change impacts, from increasing pollution. Even though New York's done a good job on pollution abatement, it has not succeeded. If you've ever been in a hospital in the Hudson River Valley, in the emergency room with a child or another individual suffering from asthma, we have right across New York tremendously high asthma rates, and that's all from air pollution, and that denies our birthright to clean air. I think today Pete Seeger is singing us a song. Pete Seeger would be so proud that his work with the education efforts of Clearwater have turned into a Bill of Rights provision, a right to protect the clean water of the Hudson and of the state of New York. So Pete Seeger, we're in your debt. You were there before the constitutional amendment and you knew we needed it. Now, this birthright, which is self-executing, during the debate about adopting it, people said, oh, it's going to cause a lot of litigation and be a problem. Well, it doesn't have to. Every part of government has a duty to implement the right to clean water, clean air, and a healthful environment. So my recommendation is if you're a member of a town council or a village board, you ought to do a little environmental audit to see, are you fully in compliance with your environmental laws, or is there a risk that you're denying the clean air and clean water to some of your citizens in your township or persons in your village? I think we've all got to take, as Senator Harckham said, recognition that we are now on the other side of a divide. Things have changed. They've changed fundamentally in New York. So all of us, all government officials have an obligation to protect the environment. I served 2 terms on my local school board for my school district. One of the things we did was establish to the annual budget vote a separate vote asking the people in our school district to buy a new school bus every year. That way we could always have a new up-to-date school bus that was safe and at least had as much compliance with the air pollution laws as we could get from a tailpipe. Well, the next round of school buses is going to have to be electric. Governor Hochul has said we need electric buses by after 2030. Well, frankly, we need them now. And if you're in a school district that subjects the children getting on and off a school bus to particulate matter and emissions that harm their lungs, that school district needs to say, I don't want to violate the Clean Air Amendment, the Clean Air Right in New York. I'd better look at coming up with a better emission control system or altogether go to an electric school bus. So we've got these kinds of missions. Every time you appear before a planning board in New York, anywhere in the state, you ought to be invoking the healthful environment right that you have. Clean air, clean water, and a healthful environment. We've got to begin raising the bar, implementing the laws that we have now in a rigorous way, and secondly, anticipating that where our rights are being denied, government has to act. So there may well be a need to bring lawsuits. It's going to be very difficult to bring these lawsuits. They're not enforcing this right. They're not easy to bring. You have to have a good record and really prepare carefully. This does not authorize citizens to sue polluters or private parties. That was clear in the legislative debate. This is an individual right that you have. It's not a citizen suit provision. And it is a right that the government is obliged to provide to you. So it's our challenges to the government. There's no going to be a big campaign like toxic torts or the plaintiff's bar to raise a lot of money for lawyers here. This is going to be about equitable remedies, about ordering a governmental agency to act to secure your right and liberty, your right to environmental liberty. And so it's a very exciting change that we have. It's a whole new era of environmental jurisprudence. We tried to get this in 1969 when we adopted the first major environmental laws, the National Environmental Policy Act, and we amended all our laws in New York, but we only got partway there. This amendment pushes us over the top of the divide to the other side. It's been 50 years in coming. It's here, and all of us, I think, have an obligation to put it to work. So I think what Pete Seeger would want us to do at this point is to break out into song, but we'll have to get on to more boring topics. Thank you very much, Matt.
Thank you, Professor Robinson, and singing will be after the program. Just a reminder to all the folks who are on the panel, if you have a specific question, please put it in the Q&A, just so it doesn't get lost in the chat with all the other comments. I'd like to go now to Seth to ask, what will the environmental right, because now it is in the Constitution, it is our environmental right, it is no longer an amendment. What will the environmental right mean for day-to-day litigation?
Well, thank you, Matt, and thank you to my fellow panelists. I want to really thank both Maya and Nick for what they've done, in Nick's case, over several years, and Maya's a few less, but equally important to getting this thing passed. It's really a great achievement. I have had nothing to do with this. I've just been standing on the sidelines, but I've been cheering very loudly. I have become very interested in the question of what is a fundamental right, how do fundamental rights get recognized, and more particularly, why can't we all acknowledge that the right to clean air, clean water, and a healthier environment is basic to human life. It was an eye-opening experience for me a few years ago when I was judging one of the rounds in Pace's environmental law moot court competition, and the case that year was very much patterned on the case that many of you probably heard about in Oregon, where groups of young people, children, were suing the government for not adopting laws to protect them from climate change down the way. And one of the main issues there was, were these plaintiffs advocating for a fundamental right? And one of the very talented young lawyers, law students, had to argue the point that no, it wasn't a fundamental right, and fundamental rights are what's in the Constitution. And here I was realizing that I was living in a country that recognized more of a right to carry a gun around than to breathe clean air. I said to him, for me, breathing is a very fundamental activity. I don't know about you, but we've come a step closer towards recognizing that. And it's important in the practical sense, and I'll get into that more specifically, but as Nick pointed out, there is a movement in the United Nations to recognize it as a basic human right. So far, the United States has not exactly been quick to support that. That's something else we need to be leaning on our representatives in the United Nations to be doing. Many countries around the world have environmental rights provisions in their constitutions. We don't. The fact that we have 3 states putting it to state constitutions is very important. The fact is that right now, with this in the New York's Bill of Rights, right to a clean environment is fundamental in New York State, which means that any environmental claim in a New York State court, and I would hope in a federal court sitting in New York, becomes a potential constitutional claim. Importance of that is that all of a sudden, it's very clear that the clean environment, the rights to clean air and clean water are subject to due process of law. They're subject to the Equal Protection Clause of the Constitution, which is a tremendous, powerful tool that lets the individual claimant move beyond what the legislature or administrative bodies can allow. Thinking about environmental justice in particular, it's no longer going to be enough for a community to say, well, we have laws on the books and we enforce them and they're there. No, you need to look and see, are the people in your community getting this equal protection of the law, protecting the air that they breathe and the water they drink the same as wealthier communities further away from them? All of a sudden, constitutional protection attaches to those claims, and I'm very hopeful that something can be done. The history of environmental law began with the fight to bring an action we in the legal community call standing. It's always been a hurdle in environmental cases to try to get the ability to bring a suit for an environment, addressing an environmental injury. When I was in law school, we looked at cases that wrestled with the issue of whether trees and streams have standing, and it took some tremendous activity in cases like the Storm King case to recognize the rights in some cases for these suits to be brought. Regrettably, that standing has been whittled down in several areas through the years. This amendment puts the impetus in the other direction. It's going to, I think, be more possible to get past the hurdle of lack of standing in environmental cases, particularly in New York under the State Environmental Quality Review Act, where standing has become an increasing problem throughout the years. Raising this fundamental right makes it more of a tool. And if you look at the broader scope of things nationwide, we all are aware of what's going on in Washington or what isn't going on in Washington. The basic fact here is that the foreseeable future, environmentalists are going to be looking to states and in litigation looking to state courts to get the kind of redress they need. And having recognition of clean air, clean water, and a healthful environment as a basic right of the citizens of New York is a major step in that direction.
Thank you. And we have been getting some questions already. There will be a Q&A portion at the end. Your question might be asked during the panel. This question I have is for all of the panelists. And why don't we start with Nick? Pretty briefly each, could you give me an example of how the environmental right would stop an environmentally destructive project from happening?
Well, before a project can go forward, throughout New York, we have a robust body of laws at all levels. You have to get a state permit or a local permit. You have to have authority to do your project. And that's a government act. In the past, sometimes it was subjected to the State Environmental Quality Review Act, seekers' environmental impact assessment proceedings. Rather recently, a number of state and local agencies have been bypassing seeker by claiming that the action has no environmental impact or they can mitigate all the adverse impacts conditionally in advance. But now that agency is going to have to ask the question, does this proposed project harm or degrade clean water, clean air, or a healthful environment? Now, water and air in New York is already under stress. So the way environmental laws work, you're not supposed to make it worse. You're always supposed to clean up the environment and make it cleaner. So that if by adding some pollution or some adverse impact, you're causing, or you could possibly cause a regression in environmental quality, a decline, you should not do that. Either you should make sure that doesn't happen, or enter into an agreement to have an offset or some conditional way of compensating for any unavoidable impact so that you neutralize the impact on the overall air quality, water quality, or healthful environment. So I think it has a direct impact on the assessment government agencies are going to be making for not just projects that clearly harm the environment, but for all projects.
Okay, now same question to Maya. Could you give an example of how the environmental right would stop an environmentally destructive project from happening?
So two ways. First off, I think that Professor Robinson spoke very eloquently to sort of the substantive side of the assessment, but there is also a procedural side to it. And one of the things that we see in Pennsylvania and Montana that have had their green amendments longer and actually put into action is that in addition to having to look at the substantive impact on the waterways and the amount of pollution that's coming in and the adverse impact, there's also a requirement to make sure that government officials have engaged in informed decision-making. And so we have seen several instances where permits have been granted for industrial gold mining operations, the spreading of sewage sludge, and part of the legal challenge, part of it was based on the environmental impact, but part of it was based on the fact that the government officials were unable to demonstrate that they actually considered the relevant science that would tell them what was going to be the environmental impact. They failed to look at the existing conditions and what would be the cumulative impact of this additional level of pollution. And that failure to engage in informed decision-making was in some instances the primary underpinning of the decision that the government had failed to fulfill their constitutional obligation. And so those permits actually had to be voided, had to be rescinded, had to be pulled back, giving the government officials the opportunity to engage in the proper procedural review and substantive review or not. And I will tell you, in the situations that I have in my mind's eye right now, in every instance where the permit was actually rescinded, it was never reissued. And I can only say that that is because the government probably couldn't demonstrate that they were going to meet the constitutional threshold. So that's just my contribution, my addition to what Professor Robinson said on the substantive front.
Thank you. And same question to Seth.
Yeah, that I just want to underline what Justin said. That's a really interesting observation that things worked out that way. One of the key things is the factual record here, and this amendment opens up a lot of doors for litigants, but getting into that door isn't enough. The case has to be there. When you make a claim that you're being deprived of your clean air, clean water, or healthful environment, you've got to have the facts to back it up. When you're challenging a governmental action, you've got to tear into that administrative record, tear into what they have, see if it holds up. And on the same side, if you are the government, and I've been in the situation of being chair of the local planning and zoning board, having to defend suits like this, building that record is essential. Looking at all the issues is essential. What this amendment does is just lay a substantive norm out there that it's not enough just to go through the motions and pile up a stack of papers and say, look what we did. The answers have to be there. But just stress again, the burden is going to be equally on the citizens who are going to be challenging this to get their act together and get the record in.
Great. Maya, earlier you sort of touched on other states and our relationship with them a bit. Could the environmental right in New York affect the degrading activities of other states?
So New York's Green Amendment is going to be used to hold New York government officials accountable. So you're not going to use the New York Green Amendment to address what Pennsylvania government officials are doing or the failure to fulfill their legal obligations under Pennsylvania law or the Pennsylvania Green Amendment. But, you know, if one of the things Professor Robinson and Seth and I were actually talking about, along with you, Matt, was that there are situations, there are dynamics where you actually have multi-state decision makers, where the Green Amendments, if they are in play in multiple states, could actually have a really powerful synergistic effect. And so one of them is the Delaware River Basin Commission. The Delaware River Basin Commission is a regulatory agency responsible for the Delaware River watershed. The commissioners are the governors of each of the 4 watershed states and a representative for the president. And so now when the New York commissioner is rendering decisions that will impact the basin, they are now going to be bound by their constitutional obligation to ensure that that decision protect the environmental rights of New Yorkers. Pennsylvania, the other state that has a Green Amendment, is going to have to do the same with regards to the implementation of Pennsylvania's Green Amendment for Pennsylvanians. We actually do have Green Amendment proposals advancing in New Jersey and Delaware. So hopefully one day soon, I can say the same will apply to them. But right now it's New York and Pennsylvania. And so in that context, while New York's amendment's not going to affect directly Pennsylvania government officials and vice versa, it should affect how they participate in that joint decision-making effort and could therefore really help raise the bar, you know, lift all boats in terms of environmental protection in that context.
Mm-hmm. How could that affect the boundary between Pennsylvania and New York, that both sides now have a Green Amendment?
Well, again, the way that's going the way the boundary is going to be affected is Pennsylvania is going to have to do it better and New York's going to have to do it better. But if Pennsylvania, let's say, allows fracking to happen all along the ridgeline on the Pennsylvania side of the state, and all that pollution is spewing over into New York, you're not going to be able to use the New York Green Amendment to go after them. Pennsylvanians are going to have to use the Pennsylvania Green Amendment to talk about their environmental rights and get better protection that way. But your example is a really good reason why, in addition to having Green Amendments in every state constitution across the nation, that part of my Green Amendment for the Generations movement is also about getting a federal Green Amendment. That is going to be step 2. But given the level of power that the states have for environmental protection, given that constitutional amendments are more accessible at the state level, and given that you need 3/4 of the states to be on board with securing a federal green amendment, it's strategically smarter and better and will be more successful to start with the states first, which is why that's our strategic approach. But we will ultimately want and need a federal green amendment, because that will provide a powerful tool to help us better address these cross-boundary issues, as well as sort of the engagement of the federal government to help deal with those situations. But New York's going to affect New York. Pennsylvania is going to affect Pennsylvania, and it's one of the reasons why we needed a green amendment in every state and at the federal level, because then we cover everything.
Yeah. And going off of that a little bit, talking about the individual states and their legislation, I wanted to ask all the panelists, starting with Seth, how will this affect the implementation of legislation on the state level?
Well, as I see it, there is now a reinforced duty on the part of the state to implement their laws and to do it properly. Now, there's been a whole history of cases where, hold on, I just lost my thought for a second. Federal laws, for example, in most of the environmental laws, provide citizen suit provisions where citizens can sue state governments for not enforcing their laws properly. In most cases, it's become a complete defense in those suits if the governmental agency can say, I've been diligently prosecuting it. Look, I've put in an effort and I've done my job. Seems to me that this amendment now adds a substantive norm that a court now should have the power to look into the quality of that enforcement, to look into the ability of, look into how effective the enforcement is. You know, there's a whole history in the 70s when the federal media statutes were set up, and specific deadlines were put in by Congress for regulations to be implemented. In many cases, particularly under the solid waste law provisions, the Resource Conservation Recovery Act, they had to sue the EPA to issue the regulations in time. Those are very, very difficult suits. Similar suits could be brought here. It's a difficult road to travel, but at least that right is in there, and the possibility is there. Again, the biggest concern I have, you know, right now, by and large, we have in New York, where I practice, although I don't live there anymore, we have pretty good enforcement. We have a government that's pretty well committed to it. But there may arise over Egypt a king that knows not Joseph someday, and we may have to put the government's feet to the fire and make the enforcement happen.
Right. And I'd like to ask the same question about implementation of state legislation to Nick.
Well, thanks a lot, Matt. I think the Department of Environmental Conservation will now have to review what it does under the existing powers that are in the environmental conservation law, existing authority, and see whether they can do more to ensure that a person's right to clean air and clean water in a healthful environment is not abridged. Take, for instance, the water quality standards. We classify all the streams and rivers in New York with water quality standards in order to make sure that we don't allow more pollution to degrade that water. We're also always supposed to be increasing the cleanliness of that water. Well, the division of the budget at the request of the former governor cut back the Department of Environmental Conservation very substantially. I mean, there's about a third fewer people doing enforcement than I was the general counsel of DEC. That's not excusable. This has allowed degradation to take place, or a lack of attention for reversing degradation. And so I think the division of the budget is going to have to reassess the needs of the department where there are insufficiencies in implementing our state legislation. I think the other area where we find government under criticism is in the area of so-called environmental justice cases, EJ. These are cases where the DEC or a town or a village or agency has allowed a project to go forward which has a disproportionate bad impact on people of color, on areas where the minorities in the population may be concentrated in their housing. And that violates equal protection of the law, which is a First Amendment, our Bill of Rights right. It violates due process of law. Now, it also violates Article 1, Section 19, the environmental rights. So I think we're going to see the deficiency in environmental justice cases advanced now. I also think that in many instances, the Attorney General of the state of New York, with her powers and her very fine Bureau of Environmental Protection that's been in place since Louis Lefkowitz's days as Attorney General, that Bureau is going to be able to do more to enforce state legislation, and also has another way to defend state legislation when it's attacked by parties that maybe want to perpetuate their economic advantage in having pollution or externalities. So I think it's going to have a contextual impact. We don't know the answer to your question until we see where the right is being denied. It'll always be in a specific fact pattern. And then we have to build that data. And as Seth says, we have to really show and prove with scientific evidence that it's being abridged. And then I think the courts have an obligation to guarantee the person's right if it's being denied.
Right. And Maya, same question to you about implementation of state legislation.
So I sort of feel like my two colleagues have answered it pretty solidly. So I don't want to just speak in the interest of speaking, other than to just sort of put a period or exclamation point on the end to really say that this is, in terms of the laws that exist today, all of those state laws will now have to be interpreted and applied through the lens of constitutional environmental rights. And so no longer, if a law is primarily about permitting and says, well, you can develop your new industrial operation so many feet from a residence, or so, new development so many feet from a river, as long as you get XYZ permit. No longer is it enough just to comply with the letter of that regulation or that legislation and say, okay, we're allowed to emit so much pollution into the air. Here's your permit. There now has to be an additional level of review. If I were to issue that permit in that place, in that way, in that location, meeting those standards, will it result in a constitutional violation? There's now a new level of review, right? So you're both, one, interpreting the law through the lens of how do I implement this law in a way that ensures protection of environmental rights, but also I have to now do an additional constitutional review to say, if I implement the law this way, will it result in a constitutional violation? So you have that additional layer. And then just also to really emphasize this idea that if there is a gap in the law, like we had for PFAS, one of the reasons why we have PFAS poisoning so many waterways and so many people's bodies is because there has been for years and years and years a gap in the legislation and regulation with regards to PFAS. There wasn't any. So industry was able to use it indiscriminately, and government did nothing. And it was very difficult for government to do something in light of that gap. Well, if there had been a New York Green Amendment at the time that PFAS started to be used in the state of New York, government regulators could have turned to their constitutional obligation to protect the right to clean water, looked at the science and said, you know what, we are not going to allow you to use these dangerous toxins because it will result in a constitutional violation. Or if government was allowing it to happen, the people could have come to government from Hoosick Falls. They could have gone to government and said, look, here's the science. This is damaging our right to clean water. You must put an end to it. And by the way, you must also take action to clean up the devastation that's happened, whether you do it directly as a government entity or require responsible parties to do so. So it really does change the landscape. And do you want me to answer the inaction question now, or wait, are you going to pose that later?
I'll pose that one a little bit later.
Got
But
it.
I love the enthusiasm. Going off of PFAS though, Seth, so Maya sort of addressed that if this amendment were there, if this right were there earlier, it wouldn't have produced the PFAS. Now that we have PFAS because we didn't have the amendment, what does the right affect the remediation process?
Well, everything she said is absolutely true, and I would just add that the amendment enforces the rights of the people to seek redress now, the people who were harmed by this, people in other communities. This is a classic example of science getting ahead of regulation, that for whatever reason, government did not regulate PFAS or identify it as hazardous fast enough. Now it's no longer a defense to say there's no standard that applies, so everything's okay. If clean water in a healthful environment is impacted, it's actionable.
Mm-hmm. Okay. Going to Nick now, I'd like to ask about what this will mean for citizen actions relating to due process claims. If you could comment on that.
Well, that's an important point. The nice thing about due process of law is that those words have been around since the Magna Carta in 1215. And they're general words: due process of law, the rule of law. You don't know what is denying the rule of law until some government agency does it. And then you can go before a court and try to get the rule of law observed and try to challenge that. That's what government accountability is all about. The same thing is true with equal amendment, treating people fairly. We all know fairness is something we sort of understand instinctively, but until an unfair act takes place and government is making it take place and it treats you unfairly, then we now know the specific application of fairness. So in case of clean air, clean water, and a healthful environment, we sort of know it when we experience it. What Steve Engelbright, the first and lead sponsor for this legislation, said during the congressional or the assembly debates on it, he said the people know what clean water is. They may not know all the chemistry about it, but you basically want to drink water to slack your thirst, to refresh you, to keep you healthy, and you don't want it to be contaminated and make you sick. That's not so complicated, but establishing what caused the contamination of the water and how the government let that happen, that, as Seth has said, and Maya also, requires a good, solid scientific evidentiary proof. Once you've got that proof, your right is there to be invoked. So, and the same thing, as I said before, on equal protection, and it will enforce this, make the civil rights laws and the due process provisions of the civil rights laws much more effective in environmental justice cases, because you've got a fundamental right in New York now. It's not just a right that spins off of due process or equal protection. There could be many applications for discrimination other than the environmental ones, but now the environmental ones have given some priority.
Right.
So I think it's a very important complement to due process of law. The two are in the Bill of Rights. The Bill of Rights is the most fundamental place in our Constitution for your personal basic rights. And these are rights that each individual has had ever since November 2nd. So you've got them as personal rights and you got to stick up for them.
We'll try. Going back to Maya, I wanted to ask a little bit about environmental justice communities because they are disproportionately affected by environmental degradation and types of pollution. So how will this directly help EJ communities?
So I want to let folks know that I actually authored a piece on this that was published in the American Bar Association Natural Resources publication. And so you can find it at the forthegenerations.org website on the resources page. And it goes into great detail. So for anybody who wants to sort of really dig in and learn more, but essentially it's pretty simple, right? Just like everything, frankly, about this constitutional right is pretty simple, because now all the people have the same constitutional right to clean water and air and a healthful environment. If a community can demonstrate that it is being disproportionately impacted as compared to everybody else, they now will have a constitutional argument. I mean, it's almost as simple as that. Now, we have a lot of cases in Pennsylvania and Montana that are really demonstrating how the Green Amendment works in a variety of different contexts: legislation, regulation, decision-making, attorney general cases. We haven't yet had a really good example of an environmental justice case, but I do believe, from all of my legal analysis and what we've already experienced to date, that it's just a matter of time before we have that most powerful environmental justice case. And again, it's really pretty simple, because we all have the same constitutional right to a clean and healthy environment. If you can show a disproportionate impact for one community as compared to all others, then you can demonstrate that there is potentially a constitutional violation. You don't have to prove that there's an intentional motivation behind it that's driven by race, etc. You just really have to focus on that disproportionate impact.
Right. Thank you. So a big issue that New York had in regards to the environment before I started doing any of this work was the campaign to ban fracking. Now, in New York, we have a moratorium on fracking that needs to be renewed every couple of years by the legislature. So I wanted to ask Seth if he feels that the Green Amendment could permanently ban fracking in New York.
Well, the amendment itself can't. People going to court or people becoming activists and using the amendment might be able to. The ban's not permanent. I could conceive of a suit saying that the lapsing of that ban could be a deprivation of the right to a clean environment. But again, there's a factual showing that has to be made. People have to show that their environment is being addressed adversely. It's got to be more than speculative. You've got to show an actual effect, which is something that's capable of being done. So it does open that door. More important point is we're looking at a situation now where we've not had comprehensive, substantive federal environmental legislation for decades now. And we're not likely to see any in the future. And it's particularly of concern in the area of climate change, where we've had to go to great gymnastic feats to get the Supreme Court to recognize in Massachusetts versus EPA the ability of the EPA to regulate carbon dioxide emissions, greenhouse gases. The recognition of a fundamental right, and this is just one step towards that, as Maya pointed out.
Right.
This gives individuals and the court, through the courts, the right to force legal action where the government has refused to do so. And you know, to the extent this amendment is self-executing, that doesn't mean, we could all light up cigars and celebrate. No, we've got to be the ones to execute it. We
Right.
need to have these lawsuits brought. We need to have action. We have more capacity to do it now, but it's up to the concerned people to do it.
Right. And Maya, did you have anything to add to this fracking question?
Yeah, so just a little bit of a different perspective, but building on what Seth said. So if the government was in a position where they were going to choose not to act and allow the ban to lapse, opening the door to fracking, I actually do think that there could be a claim to say that failure to act, and we'll speak more about the failure to act later in different contexts, but really that failure to act will result in a constitutional violation of the rights of the people to clean water and air and a healthful environment. So well, first off, in the first instance, the government should rely on the amendment to uphold the ban. They can look at the science and the facts of what's happening everywhere else, how devastating fracking is, and easily use the amendment right as that foundational basis to keep it in place. If they choose not to do that, I think that the people could probably have a pretty darn strong argument that failure to act is in and of itself a constitutional violation. And if that were not to work, then when the first next step took place, perhaps the issuance of a permit that allowed fracking to come into a community, I think there again, the people would have a very strong argument based on law, based on the constitutional Green Amendment, that the granting of that permit is going to result in a constitutional violation. And therefore that approval, that government action could be defeated on constitutional grounds. There's a really powerful quote. I won't say it exactly, but it came out of the Montana Supreme Court, right? One of our Green Amendment states, one of our only 3 Green Amendment states, that says something on the order of, you don't have to wait for the fish to float dead on the top of the water before you can bring action under the Constitution to protect the right? Or before you can find a constitutional violation, something like that. So in the context of fracking, we have so much scientific evidence and factual experiential evidence that fracking, if allowed to happen, will have devastating consequences for the impacted communities and for the impacted environment. I think now that New Yorkers have this Green Amendment, they have the ability absolutely to prevent that industry from being able to come into the state of New York. I believe if we had had a living, thriving Green Amendment when fracking tried to come to the Commonwealth of Pennsylvania, we could have kept it out. But we only got our living Green Amendment later, after the industry had already proliferated. So it's now an entirely different ballgame, although we're having tremendous success because of our Green Amendment. But in New York, it's not here yet. And I think that the Green Amendment can be used absolutely to keep it out.
Yep.
Can I ask,
And,
have you had
yep.
any success in Pennsylvania getting them to trim back once the environmental amendment has been in there?
So we've had a number of really important successes in and out of the fracking context. And so I'm just going to give you 2 really quick examples. The Pennsylvania legislature, and this is actually the first most powerful use of the Pennsylvania Green Amendment brought by my organization, the Delaware Riverkeeper Network, and me and my role as the Delaware Riverkeeper, along with 7 towns. And this is what gave Pennsylvania's Green Amendment legal life in the first place, and is why I founded the Green Amendment movement and defined the term Green Amendment. But the Pennsylvania legislature in 2012 passed a law called Act 13 that was really a gift basket to the fracking industry. It preempted local zoning authority and mandated that fracking be allowed to happen in every part of every community. Residential districts, agricultural zones, historic preservation zones, environmental preservation zones. Local towns were not allowed to use their zoning authority to limit fracking to where other industrial operations were happening. It also put in place automatic waivers from environmental protection standards that applied to every other industry, but now would not apply to fracking. It alleviated the industry of the obligation to notify those on private drinking water wells that their drinking water had become potentially contaminated by nearby fracking and more. And we actually challenged that pro-fracking law, arguing that these provisions and others, if allowed to go into effect, would result in a violation of the environmental rights of the people of Pennsylvania, as well as usurping the constitutional right and authority of the local towns in that zoning context. The Pennsylvania Supreme Court, very conservative Supreme Court at the time, in significant reliance on the Green Amendment, declared those provisions to be unconstitutional. And so as a result, we prevented the exponential proliferation of fracking that would have happened because of that law. Another really powerful case was the Green Amendment that has been used in Pennsylvania to prevent the misappropriation of environmental protection funds. And the Pennsylvania Supreme Court, even more recently, has been very, very clear that the generational language in Pennsylvania's Green Amendment requires future generations to be protected equitably with present generations when it comes to environmental rights. That case was also in the fracking context. So there are more, but those are just a few examples of how we've changed the playing field only because we had a Green Amendment in Pennsylvania. If we didn't have it, things would be dramatically worse than they are now.
And Maya, you've alluded to this before. We've been talking about states, and you've mentioned you're trying to do this on the federal level. Right now, we are seeing a lack of action in Washington on behalf of climate action, lack of Build Back Better passing, and so on and so forth. So is the environmental right in New York enough to sort of fill in some of those gaps?
In the climate context? Yeah, so we believe that absolutely the language in the New York Green Amendment about the right to clean water and air and a healthful environment can be used to build a case in the climate context. How that case is going to be framed out, exactly how one would approach it, you know, we will have to think about. But because climate change has such harmful impacts on clean and healthy water, air, and environments, as well as the human health qualities of the environment, the healthful qualities of the environment, we believe that this could be a key foundational piece in New York in the climate context, but we have to think a little bit more about how we would actually develop that out and pursue it.
Right. Nick, same question to you.
Well, the Green Amendment will breathe priority into worrying about climate change. As everyone on this webinar probably knows, there is a public comment period open right now for our state to put comments in on the Climate Action Council's proposals for scoping what New York should do about climate change. And I think it's incumbent upon us all to go online, put in our public comments, and then at the end of that, take a good look at what the state is promising to do about climate change based on this analysis. If it comes up short, then I think the Green Amendment would give us a basis for challenging that inadequacy. But we have to participate in the process. We can't preempt it. We need to get out front. The Green Amendment is in effect right now. Nothing that went before November 2nd is grandfathered. Nothing that went before the adoption is exempt from this new basic fundamental human right to clean air, clean water, and a healthful environment. So you can test ongoing shortcomings against this if your personal rights have been denied. The next tragedy of Hoosick Falls has never to happen. But if it's happening, then there ought to be remedial measures. And what you can do, of course, in bringing those suits is shift the burden of proof to the government. Usually right now, under the citizen supervisions, the burden of proof is on the citizen to prove the polluter is polluting. Well, now what you have to do is simply say, I am a person, I am a New Yorker, and my environmental rights are being denied by government agency or government board. And I want the court to order them to stop harming my environment. Well, now the burden shifts. The government board, the government agency has to say why they're not denying you your right. They have to prove that they're not contaminating your health or whatever it is. So it's a very powerful tool to basically hold our state government accountable. It's the same as in due process of law. You don't say, I'm in jail illegally and they've leave me here while you test my constitutional right not to be here. That can be heard right away and the evidence put forward.
Right. Yeah, I'd like to start addressing some of the questions from the audience, starting off with William's question to all the panelists, starting off with Maya. Do you think the Green Amendment will allow for standalone suits against public entities? Would there necessarily need to be government action in order to bring a suit, or would inaction by the government be enough?
So I have a really great example to prove the point that inaction is action and therefore could be subject to constitutional challenge. So number one, just to validate, William, yes, your lawsuit in the constitutional context would be brought against a government entity, right? It might be a regulatory agency, it might be an elected body, but you have to, it's got to be government action of some kind. Now, in the environmental context, actually in environmental law, there's a lot of precedent for the idea that inaction is action, a failure to render a decision or take action, that inaction is action. So in this constitutional context, we have that belief as well, that the failure of government act to address a constitutional violation, finding that decision point, that is that failure to act, can be action that can be challenged on constitutional environmental rights grounds. And by way of example, in the Commonwealth of Pennsylvania, there is actually a highly toxic site known as the Bishop Tube site that has been in a supersaturated toxic condition since the mid-1980s. The government has known about it. There are known responsible parties that have lots of money. There are existing laws that should have required the cleanup of this site by responsible parties. And yet for all these decades, from the mid-1980s up until present day, the Pennsylvania Department of Environmental Protection has done little to nothing to secure the cleanup of that site. And in fact, in addition to doing little to nothing to secure the cleanup of the site, the government actually spent their time trying to negotiate a deal, a sweetheart deal with the developer that would allow the developer to develop this site while it was in its still toxic condition. The Delaware Riverkeeper Network, and again, me and my role as the Delaware Riverkeeper, challenged that failure of the department to enforce existing law to secure the cleanup of that site by responsible parties. That failure to act is resulting in a constitutional violation of the environmental rights of the people around. Because the one thing I didn't note is not only is the site in a super saturated toxic condition, but throughout these decades, there's been a spreading pollution plume going further and further out every day. It's almost a mile long, distance at this point. There was a motion by the DEP to get our action dismissed, making the claim that that inaction was not action and therefore it was not subject to the constitutional claim. And the court explicitly rejected that argument, making clear that inaction can be action resulting in a constitutional violation.
Right. I'd like to address this audience question to Nick, and then we should have time for one more. What if one's municipality is not complying with federal EPA environmental orders? Does New York State, and you mentioned the Attorney General earlier, does New York State have an obligation to enforce these federal non-compliance?
Well, due process of law is about the rule of law. So I think in the abstract, it would be hard to answer that question. You have to put it into a specific fact pattern, a situation, but I can imagine situations where that would be the case. First, most federal laws have a parallel state law environmental provision. We have a dual system. And if the Chief Judge Judith Kay published a piece in the St. John's Law Review many years ago on dual constitutionalism, that just because the feds don't take action under their due process provisions doesn't mean New York cannot take strong action, and even stronger action than a federal court would do. So I think you could make the argument that if the federal government has required it, the town or village or some board is not complying, that is denying a personal right if you are being harmed. You have to establish how you're actually being harmed in your constitutional right to the environment. But if that is now the fact that the feds haven't enforced it won't stop you from, I think, enforcing it under our Bill of Rights in New York State.
Okay, thank you. We got a lot more questions, but not a lot of time, so we'll try to get back to people after the program. I think the last question I'd like to end on, and this question is for Seth, comes from Peter. The speakers have cited the effects of the amendment, which provide a strong bias in lawsuits and administrative proceedings toward environmental rights. But is there expected to be an affirmative requirement of state government to take action to fulfill the rights?
That's a deep philosophical question.
That's why I chose you.
Oh, I'm just a poor country lawyer. Well, looking at the level of this Bill of Rights provision, it could be required. I can't, well, I think most of the cases are going to be fact specific. I think that the cases are going to come up are going to, the judges are going to rule on the case that are before them and forcibly have to limit themselves to that. But, you know, as I said, we're getting into normative questions. I could see these being looked at more and more. It's quite possible. It's kind of hard to speculate about what type of case would come about, but you know, the courts will try to limit the ruling to what's in front of them, up to the advocates to push it beyond it.
Right. Well,
can I just jump in, because there was one question that I saw pop up in the Q&A that I just loved, and somebody asked about the suit in the Netherlands brought by the government there against Shell, Royal Dutch Petroleum, pretty big operator there. This amendment could conceivably open up that type of litigation here, that private claimants could, through this, in the absence of government action, seek to hold companies responsible for harm to their environment. Tough case to prove, but you're going to see more and more of it. And in the absence of comprehensive legislation about climate change, that may be the way to address the issue.
Mm-hmm. And that question was in relation to the Shell oil company headquarters in the Netherlands. Based on a citizen's right to clean air, they were forced to reduce CO2 emissions. Yeah, thank you all so much for joining us. We're running over time a little bit. We'll try to get back to folks with answers to these questions. But I would just like to thank everybody for joining us. I'd like to thank Professor Robinson. I'd like to thank Maya. I'd like to thank Seth. I'd like to thank Senator Harckham for coming out. And as Senator Harckham at the beginning said, it's nice to revel in victories sometimes, really reflect on them, what they mean. Now is a step of governance to protect people's health, to ensure that they have clean air to breathe, clean water to drink, and safe food to eat. Clearwater has been doing this for a long time, much longer than I've been there. Anything in terms of volunteering or donations or following us on social media makes a big difference. Someone put a link in the chat to help us out. And I'd like to thank all the people who attended because you are the ones really helping to make a difference. You're the ones who came out to vote. You're the ones who are talking to people about it. Law is precedent, and it means getting something in front of a court and a judge and getting the work done. And together we are on a slow march toward making New York and the United States a beacon for all those who seek a cleaner world. And I thank you all for helping. Good night.
This land is your land, this land is my land, from California to the New York Island. Go Clearwater.
Thank you. I will not
Clearwater.
sing, but
And great singing.
Very good, very good.
Good night, everyone. Thank you.
Bye-bye.
Thank
Good
you,
night.
Clearwater and Matt.